लीगल पैसेज है जुडिशियल डिसिप्लिन at the speed of 110 to 120 words per minute. Be ready without any stop. Start. A decision of a constitution bench of this court binds a bench of two learned judges of this court, and that judicial discipline obliges them to follow it regardless of their doubts about its correctness. At the most, they could have ordered that the matter be heard by a bench of three learned judges. In a given case where a bench of two learned judges expressed dissent with another judgment of three learned judges and directed the matter to be placed before a larger bench of five judges, the constitutional constitution bench considered the rule of judicial discipline and propriety as also the theory of precedents, and held that it is only a bench of the same quorum which can question the correctness of the decision by another bench of coordinate strength, in which case the matter may be placed for consideration by a bench of larger quorum. In other words, a bench of lesser quorum cannot express disagreement with or question the correctness of the view taken by a bench of larger quorum. A view of the law taken by a bench of three judges is binding on a bench of two judges, and in case the bench of two judges feels not inclined to follow the earlier three judge bench decision, then it is not proper for it to disagree or dissent with the earlier view, but doubting the correctness of such earlier view, it can only request the Chief Justice for the matter being placed for hearing before a three-judge bench, which may agree or disagree with the view of the law taken earlier by the three-judge bench. As already noted, this view has been followed and reiterated by at least three subsequent constitution benches referred to herein above. Ms. Indira Jaising, the learned senior counsel for the petitioners, submitted that the view of the law taken by the above said four constitution benches is per incurium and is not the correct law, as previous decision of this court takes a contrary view, and being an earlier decision was binding on the subsequent benches. We do not agree with the submission of the learned senior counsel that the decisions referred to by the learned counsel are per incurium. She has also placed reliance on a constitution bench decision in Union of India versus Hansoli Devi, wherein the constitution bench heard a reference made by a two-judge bench expressing disagreement with an earlier three-judge bench decision. Per incurium means a decision rendered by ignorance of a previous binding decision, such as a decision of its own or of a court of coordinate or higher jurisdiction, or in ignorance of the terms of a statute or of a rule having the force of law. A ruling making a specific reference to an earlier binding precedent may or may not be correct, but cannot be said to be per incurium. Chief Justice Pathak pointed out that in order to promote consistency and certainty in the law laid down by the superior court, the ideal condition would be that the entire court should sit in all cases to decide questions of law, as is done by the Supreme Court of the United States. Yet his lordship noticed that having regard to the volume of work demanding the attention of the Supreme Court of India, it has been found necessary as a general rule of practice and convenience that the court should sit in divisions consisting of judges whose member oblique number may be determined by the exigencies of judicial need by the nature of the case, including any statutory mandate relating thereto, and by such other considerations which the Chief Justice, in whom such authority devolves by convention, may find most appropriate. The Constitution Bench reaffirmed the doctrine of binding precedents as it has the merit of promoting certainty and consistency in judicial decisions and enables an organic development of the law besides providing assurance to the individual as to the consequence of transactions forming part of his daily affairs. Further, the Constitution Bench, speaking through Chief Justice Pathak, opined that the question was not whether the Supreme Court is bound by its own previous decisions. The question was under what circumstances and within what limits and in what manner should the highest court overturn its own pronouncements. In our opinion, what was working in the mind of his lordship was that being the highest court of the country, it was open for this court not to feel bound by its own previous decisions, because if that was not permitted, the march of judge made law and the development of constitutional jurisprudence would come to a standstill.